Welcome to This Explainer. I am absolutely thrilled you're here today because we're unpacking a massive, high-stakes constitutional clash over exactly how we sentence the most serious crimes. We're looking at a justice system that literally divides the trial process in half and asking a really tough question. Does this split compromise a person's fundamental right to a fair trial? This is a deep dive into the fascinating tension between textbook legal perfection and the messy, practical reality of substantive fairness. We've got 6 parts on the agenda today. First, the split trial dilemma. Second, the High Court's objections. Third, redefining the fair trial. Fourth, addressing the sentencing gap. Fifth, unpacking trauma and delay. And finally, the Constitutional Court's verdict. Section 1. The split trial dilemma. Okay, let's dive into this. To really understand the foundational legal procedure at the heart of this explainer, I want you to imagine standing in a courtroom. You've just been convicted of a grievous offense. But instead of the presiding magistrate handing down your punishment right then and there, the proceedings suddenly just stop. You're told that a completely different judge in a completely different court who never heard a single witness speak will be the one deciding whether you spend the rest of your life behind bars. So ask yourself, is it actually fair to be sentenced to life in prison by a judge who never even saw your trial? Well, this isn't just some hypothetical scenario. It's the actual real-world mechanism created by Sections 51 and 52 of the Criminal Law Amendment Act. The law dictates a strict split procedure. Here's how it works. The regional court conducts the trial and issues a conviction if the evidence demands it. But for certain severe crimes that carry incredibly heavy minimum sentences, the regional court simply lacks the jurisdiction to impose that penalty. So they have to hit pause and commit the accused up to the High Court. The High Court then takes the written transcript of the trial, just the paper record, and issues the sentence. To put this into perspective and ground it in the specific facts of our source material, let's look at the real people who got caught in this procedural web. We have George Sakuda, Winston Tilley, and Malope John Shillo. In entirely separate regional court cases, all 3 of these men were convicted of raping girls under the age of 16. It's an undeniably horrific, heinous crime. And because of the extreme severity of these offenses, the law explicitly prescribes a minimum sentence of life imprisonment. Consequently, the regional magistrates had no choice but to stop the proceedings and send these 3 men up to the High Court for their final sentencing. Section 2. The High Court's objections. Now, when these cases arrived at the Witwatersrand High Court, they hit a massive judicial brick wall. Judge Lewis looked at this split procedure under Section 52, really evaluated its impact on the accused, and decisively declared the law unconstitutional. She didn't just reject it out of hand, though. She laid out 4 very relatable, highly structured objections. First, the literal fragmentation of the trial process itself. Second, the loss of the trial's unique atmosphere, all those subtle nuances of live testimony that a sentencing judge would completely miss. Third, the potential for double jeopardy and the psychological trauma of forcing witnesses to testify all over again just for sentencing. And fourth, the extreme institutional delays that this clunky administrative handoff creates. And this brilliantly illustrates the core anxiety of the High Court. As Judge Lewis wrote, a sentencing court working from a bare record is fundamentally disadvantaged. Think about it. You just cannot capture the hesitation in a witness's voice or the subtle demeanor of the accused on a typed piece of paper. To the High Court, forcing a judge to make literally life-and-death decisions based on a paper transcript was so incredibly far from an ideal procedure that it essentially violated the constitutional right to a fair trial. On top of that, the High Court pointed out a pretty shocking administrative reality. In 44% of these cases in the Witwatersrand High Court, the transcripts they received were so insufficient that judges had to halt everything just to formally request the original magistrate's written reasons for the conviction. That is a staggering bottleneck. This constant back and forth caused agonizing delays for the accused, who just languished in prison, wrapped in anxiety, waiting to finally find out their fate. Section 3. Redefining the fair trial. So the High Court's ruling threw the entire criminal justice system into a state of total uncertainty. That's when the Constitutional Court of South Africa had to step in to review this declaration of invalidity. And here, guided by Judge Ackermann, the whole narrative takes a sharp, highly philosophical turn. Judge Ackermann delivered a profound counterargument that is absolutely central to how we understand constitutional law. He totally agreed that the split procedure might not be the ideal way to run a trial. But, and this is key, the Constitution doesn't demand a flawlessly perfect procedure. It demands a fair one. Deviating from a textbook ideal doesn't automatically mean a person's rights are being violated, as long as the system effectively secures justice and functional fairness. To really prove this point, the Constitutional Court looked at how sentencing actually works in practice. In law, there's this foundational principle called the triad of sentencing. Essentially, a judge has to balance three concrete things: the nature of the crime, the personal circumstances of the offender, and the interests of society. Judge Ackermann pointed out that sentencing is based on these objective, measurable factors. It's a calculated normative judgment. So that elusive atmosphere of a trial courtroom, it actually isn't strictly necessary to weigh those three elements fairly. Section 4. Addressing the sentencing gap. With this philosophical groundwork laid out, the Constitutional Court systematically began to dismantle the High Court's fears about judges being severely disadvantaged by working from a so-called bare record. Now, what's really interesting about this is that they exposed a fundamental misunderstanding of the law itself. You see, the High Court viewed themselves almost like an appeals court, stuck with whatever pieces of paper were handed to them. But the Constitutional Court clarified that, under Section 52, the High Court actually exercises original jurisdiction. They aren't trapped by the transcript at all. If they need more information to sentence someone fairly, the law fully empowers them to summon witnesses, demand documents, and hear brand new evidence. Judge Ackermann then offered a brilliant and honestly somewhat surprising observation about that much-defended trial atmosphere. The Constitutional Court noted that, hey, if you've just been convicted, it usually means the trial judge completely rejected your testimony and found you untruthful. Subconsciously, that same trial judge might carry that negative atmosphere right into the sentencing phase. Escaping that toxic atmosphere and being sentenced by a fresh, completely objective High Court judge who is working strictly from the facts might actually be a huge advantage to the convicted person. Section 5. Unpacking trauma and delay. But wait, what about the human cost here? Let's unpack the final two major objections raised by the High Court: the fear of traumatizing witnesses twice by calling them back to court, and the undeniable reality of those huge institutional delays. The High Court was terrified that because Section 52 allowed them to call witnesses, they would inevitably be forced to drag victims back to the stand, causing immense double trauma. The Constitutional Court's response was essentially, well, only if you choose to, right? Just because a law allows a judge to gather evidence certainly doesn't mean it forces them to do it in an oppressive way. Judges are bound by the Constitution. It is entirely the judge's job to manage their courtroom fairly, ensuring the accused gets a fair sentence without unnecessarily traumatizing anyone in the process. And when it comes to those agonizing delays, the Constitutional Court drew a hard line in the sand between pre-conviction and post-conviction delays. Look, if you're delayed before a trial, that is a massive violation of your rights because you are still presumed innocent. But in a Section 52 split trial, the delay happens after a guilty verdict for a highly severe crime. The presumption of innocence is completely gone at that point. While administrative slowdowns are incredibly frustrating and absolutely should be minimized, a post-conviction delay just doesn't automatically render the underlying law unconstitutional. Section 6. The Constitutional Court's verdict. So we've now seen the full scope of this legal battle: the High Court's strict demand for a seamless, unified trial process versus the Constitutional Court's highly pragmatic focus on achieving functional, real-world justice. After weighing all of this, it's time for a resolution on what this actually meant for Zukuda, Tilly, and Shiloh. So, the crucial point is this: the Constitutional Court delivered a definitive three-step order. Step 1. They outright refused to confirm the High Court's declaration of invalidity. Step 2. They upheld Section 52 of the Criminal Law Amendment Act as fully constitutional, firmly stating that a split procedure does not inherently violate the right to a fair trial. And Step 3. They sent the applicants right back down to the Witwatersrand High Court to finally face their sentencing. This whole case leaves us with such a powerful reflection on how societies actually administer justice. We so often crave systems that look completely flawless on paper. A single judge, a seamless timeline, the perfect courtroom atmosphere. But reality is messy, resources are constrained, and our laws absolutely have to adapt. This explainer really shows us that justice isn't about rigid legal idealism. It's about safeguarding fundamental rights within the imperfect systems we actually have. It begs the question, if a perfectly flawless legal procedure is just an illusion, how do we best measure true functional fairness in the real world? Thanks so much for joining me to explore this fascinating constitutional puzzle. Keep questioning and keep learning.